When you file for exceptions, can you also file a modification of support? Hi, I'm Alicia Kinchler with Kinchler Law, and today I'm going to talk about exceptions and modification of support. Now, exceptions are, sometimes I explain to my clients, they're kind of like an appeal. So when you generally have a support, either a complaint for support or a modification of support, what generally happens is that you go before a conference officer, and then if either you or either the person who's receiving support or the person who's supposed to pay support does not agree with the amount that comes back, then you can ask for a de novo hearing. That de novo hearing, or brand new hearing, is going to be heard before a master. And what that means is that they're going to take all brand new testimony, they're going to hear new evidence, and they're going to hear a new argument. Now, during that time, the master will listen to everything, and they're going to make a proposed recommendation. Once that proposal goes out, you and the other party both have the ability within 20 days to file exceptions. Now, just to kind of make it easier on my clients, I generally explain this as being an appeals kind of situation. It's not quite an appeal, but it's kind of the way that we as lay people will think about it. You're basically saying that the master made some type of wrong determination or some type of error in law that should be basically reversible. And when you file exceptions, you have to some extent state what the mistake was. Now, once that happens, it goes before a master, and the master will make a determination. Before a judge, and the judge will make a determination as to whether or not the master did anything incorrectly. Now, kind of setting that aside a little bit, what sometimes happens is that during the time that you're waiting, it can be a while. And definitely during COVID, it's been a long while for people. There are people who, in certain counties, that filed exceptions prior to the initial pandemic shutdown in March that are still waiting for exceptions hearing. And the reason why this is important is because during that time, a lot of people found that their financial situation changed. And this generally would have been a situation that would have warranted a modification of support. And the way that our statutes are worded is that generally a modification can occur where there has been a substantial change in circumstances. And we think about those circumstances being a change in income, the expenses, or something else that's relevant in the lives of the parties. Now, what I've found and what I've heard from a lot of people is that when they go to file these things by themselves, pro se is what we call it, they have trouble getting through the clerk of court. The clerk of court sometimes tell them, hey, you have to choose between either filing your exceptions or continuing with your exceptions or filing a modification. It's important to understand why this might present an issue. So in exceptions hearing, again, you're stating that the master made a decision that was incorrect in his or her finding. So let's say, for example, the master made a finding on January 1st, 2020. That means that you're saying that something that happened before that date was incorrect. But now the pandemic struck in the middle of March and you're out of work. And you don't see yourself going back to work anytime soon, or there's been some type of other change in your circumstances. Now with that, the issue becomes, what is the judge allowed to consider in the exceptions? With the exceptions hearing, the judge is only looking at what happened from the master's decision. Your change in circumstances did not happen before January 1st, 2020. So generally, they're not looking at what happened before January 1st, after what happened in January 1st, 2020. They're looking at what happened prior to that and whether or not the master made the right decision. So again, if you're having trouble getting through the clerk of court, in order to be able to at least get your filing for modification on the record, you want to make sure you're kind of pushing them to allow you to be able to do this. Now, sometimes they'll say things like, we're not allowed to schedule, we're unable to schedule it. That's something else that's different. That's two different things. Not being able to schedule a modification hearing while an exception hearing is pending is different than not being able to take a modification petition during the same time that an exceptions petition is pending. So you want to be very careful, and you want to think about how this might affect you. Again, same example. If someone filed an exceptions within 20 days of a master's recommendations on January 1st, 2020, and they're still waiting, and it's January 2021, and their circumstances changed in March, What happens if their exceptions is denied? That means that all the time that they spent waiting for the exceptions hearing, they can't alleviate themselves of the situation that happened in March, which means that our obligation is still going to be running at probably a much higher amount than they might have been able to get modified if they had done it back in March. So again, it's very important for you to understand that if you are seeking a modification of support while still waiting for exceptions to be filed, you should really try to speak to the head of the clerk's office if you're receiving trouble in being able to file a modification for support. And again, I think that we've definitely seen in this situation with the pandemic things that we haven't seen before. And I think people are really understanding that circumstances have changed. We're still dealing with a backlog of cases being rescheduled that were supposed to have been scheduled before the pandemic or during the pandemic. And I think people are more understanding at this point. But you have to make sure, especially in a situation when a lot of courts are not open to the public, that you're asserting your rights. Because again, waiting 9 months, 10 months, only to find out that your exceptions are denied and you're still going to have this higher amount, and that your modification might not be able to go back to the date that you originally had a change of circumstances, but only from the time that you filed, can be a hardship or create a hardship for someone who's obligated to pay a support amount much higher than they're able to afford. All right, I hope that you found this video helpful. As always, you want to speak to an attorney licensed in your area about the facts specific to your case. Make sure you subscribe, hit the notification button, and that way you'll get an alert whenever we drop a new video. In the show notes, I'm going to post the website, kinchellaw.com, which is our website, and you can use that to request a consultation with myself or another attorney from our office. And I'm also going to put our telephone number there, so if you want to give us a call, you can do that as well. All right, until next time, take care.